Welcome to the deep dive. When we talk about the 9/11 Victim Compensation Fund, the VCF, it's so much more than just a historic fund set up to provide some relief.
Oh, absolutely. It's not just a pot of money. We're really looking at this highly complex administrative structure.
And it's been going for decades now, with constantly evolving policies, really strict deadlines, and just so many legal nuances.
Exactly. And for those of us practicing in New York, this isn't some side interest. Understanding the VCF is, well, it's a critical strategic competence. You're dealing with immense tragedy, but you have to approach it with total administrative precision.
That's a great way to put it. It's that intersection of, public policy, deep litigation strategy, and just mounds of medical documentation.
Right. And so our mission today, and we've really tailored this for the practicing attorney, is to pull out the actionable intelligence from the VCF's own official documents, their FAQs, their policies.
We're going to try and cut through all the emotional weight and just focus on the kind of the cold, hard facts of the process.
We have to. We've basically broken it all down into 6 core questions that an attorney just has to master.
Okay, so what are they?
Well, first, who is actually eligible? Second, what's the compensation amount, with all the caps and offsets? Third, what is the exact procedure for filing?
Then evidence, right? What do you need to prove presence and severity?
Exactly. And then timing. How long is this all going to take? And finally, the big one. Why do you really need sophisticated legal counsel when the VCF itself says you don't?
Okay, so we're treating the VCF's own words as the definitive rule book here.
We are. And before we even start, we have to make one thing crystal clear. You have to distinguish between the medical part and the financial part.
The WTC Health Program versus the VCF.
Right. 2 totally separate programs, but they're completely dependent on each other. The health program, or WTC HP, does the medical monitoring and treatment.
And the VCF provides the financial compensation.
And one cannot happen without the other.
So understanding that separation is like step one. You could have a diagnosed condition, everyone knows it's from 9/11, but if it's not certified by the WTC Health Program...
And the VCF can't do a thing, it's a non-starter. That certification is the absolute primary gateway. The VCF takes the health program's medical determination as fact.
So it's all about connecting those 2 dots.
That's the whole game.
Okay, let's unpack this. And let's start with that fundamental question of eligibility and really get into those all-important and, frankly, very confusing deadlines. So eligibility, it really starts with physical presence, doesn't it? It's not just who you are, but where you were and when.
That's the first hurdle, absolutely. And the VCF is incredibly precise about this. They've outlined 3 specific crash sites, and you have to be precise with your client's location and timing.
So let's start with the biggest one, the World Trade Center site and the whole New York City exposure zone.
Right. For that area, the claimant must have been present at some point between September 11, 2001 and May 30, 2002.
That's a pretty wide window, almost 9 months.
It is. It's designed to cover the attack itself, the collapse, and then the entire period of debris removal, the cleanup, the remediation, all of it.
Okay, what about the other 2 sites?
The windows there are much, much tighter. At the Pentagon site in Virginia, the time frame is September 11th, 2001 to November 19th, 2001.
So about 10 weeks?
Roughly. And then for the Shanksville, Pennsylvania site, it's the smallest window of all, just September 11th, 2001 to October 3rd, 2001.
Barely 3 weeks.
Yeah. And they are incredibly strict on documenting that you were within those boundaries during those specific times.
But like you said, just being there isn't enough.
Not even close. The statute requires that the victim suffered a physical harm or obviously death resulting from the attacks or that debris removal.
And this is where the certification comes in. It has to be a certified 9/11-related physical health condition.
That's the phrase that matters, certified.
Which brings us right back to the WTC Health Program. So strategically, how does an attorney make sure that happens? And what if a client is sick, but the health program hasn't certified them yet?
Well, the certification process is all on the WTC HP side. They're the ones who determine if the exposure caused or worsened the condition. So your client has to apply, get into the program, get monitored, and then get that formal certification letter.
And if you file the VCF claim before you have that letter,
the VCF will just place the claim in what they call inactive status. It just sits there. They won't do a substantive review until that medical piece is locked in. And that's a really common point of delay.
A perfect example of how this whole framework is kind of constantly shifting is the recent addition of uterine cancer.
Yes, that's a crucial, very recent example. So effective January 18th, 2023, Uterine cancer was added to the list of covered conditions by the health program.
And for the attorneys listening, that's a huge strategic point. You might have clients with old denials.
Exactly. If you had a client who was denied before because uterine cancer was their only condition, you now must file an amendment to turn that denial into a live claim.
And what if they already got an award for something smaller, like, say, chronic sinusitis?
Then you file a compensation amendment. You're now seeking the much higher award that's reserved for cancer claims. You're talking about going from a max of $90,000 to a max of $250,000.
Okay, so here's the administrative hurdle. What about a claimant who died of uterine cancer before it was a covered condition? They obviously were never certified by the WTC Health Program.
Right, and that immediately triggers the need for what's called the private physician process, or PPP.
Because the health program can't certify someone who is deceased.
Correct. So the personal representative for the estate has to use this PPP to get the condition verified. A private doctor has to confirm, based on the WTC-HP's own published criteria, that the uterine cancer was related to the 9/11 exposure.
So that PPP pathway is really vital for getting over that first hurdle when the normal process isn't an option.
It's essential.
All right, let's move on to what might be the single biggest strategic pitfall here: the deadlines.
Yes. This is where so many people get into trouble.
We need to be really clear about the final filing deadline versus this rolling registration deadline.
So the good news first. The VCF is permanently authorized now. The final hard deadline to file a complete claim form is October 1st, 2090.
2090, so we have time.
On the filing, yes. But the registration deadline is the operational tripwire. It's the landmine.
Explain that. Registration is just step one, right?
It is the absolute first step. It's just a simple form that preserves your client's right to file a full claim later on. It doesn't waive any legal rights. It doesn't obligate them to file.
But if you miss it,
you are permanently ineligible. Period. It doesn't matter how sick you are or how much proof you have. Failure to register on time is a bar to recovery.
So really, an attorney's first move should be to register anyone who even thinks they might have been in the zone.
Every single person, even if they're perfectly healthy right now. Registering today preserves their right to file all the way until 2090.
Okay, so the complexity here is this 2-year rolling deadline. Let's break that down. When does that 2-year clock actually start ticking?
The clock starts on the date that any governmental entity officially notifies the person that their health condition is 9/11 related.
And usually that's the WTC Health Program certification letter.
That's the most common trigger, yes. But here's the crucial nuance. The VCF counts that 2-year period from the date of the most recent certification or notification.
Okay, that's a huge point. It requires, constant monitoring of a client's status. Let's do a hypothetical.
Sure.
Client gets certified for severe asthma back in 2015. They didn't know about the VCF. They missed the 2-year deadline to register by 2017. They're out of luck, right?
Seems like it.
But then in 2023, they get a letter from NYSERS, the city pension fund, saying their disability retirement is approved and it's officially deemed 9/11 related.
Okay, that's the new trigger. NYSERS is a governmental entity. That letter restarts the 2-year clock.
So the attorney now has until 2025 to register that client.
Exactly. And not just for the asthma, but for any eligible condition they might be certified for in the future. It's a lifeline for people who missed earlier deadlines.
So it's not a one-and-done deadline. It's a surveillance requirement for the attorney. You have to track WTC HP letters, NYSERS, NYPD, FDNY pension determinations.
Absolutely. You have to proactively manage that whole notification stream. If you have a client who thinks their deadline passed, you always check for any subsequent government determination. It can reopen the door.
And what about for deceased claims? Is the deadline different?
It operates a little differently, yes.
Yeah.
If the victim registered their own personal injury claim before they passed away, the deceased claim is automatically considered timely.
But if they never registered?
Then the personal representative, that's the person legally authorized to act for the estate, they have to register the deceased claim, and they have 2 years to do it.
2 years from the date of death?
2 years from the later of 2 dates. Either the victim's date of death or the date the VCF's private physician process verifies the condition. Again, the 2-year clock is always triggered by that official determination of a 9/11 link.
That's a critical transition. So now that we know who is eligible and when they have to act, let's get into the mechanics of the actual filing procedure and that often frustrating timeline.
Right. So you've registered, now you're filing the formal claim. But before a human being at the VCF even looks at it for a substantive review, It has to pass an initial checklist.
The minimally required documents review.
Exactly. And if you fail this checkpoint, your claim just stops cold. It stalls instantly.
So what's in that minimally required package for a standard personal injury claim?
Okay, the fundamentals first. You need the complete claim form signature page that confirms everything is true.
Okay.
And you need Exhibit A, which is the authorization for release of medical information. That lets the VCF talk to the WTC Health Program.
Okay.
Then you need confirmation of the certified condition. Now, the VCF system does talk to the health program system, but I always advise attorneys to just upload the client certification letter. It avoids any potential interagency lag.
Makes sense. What else?
Proof of presence. That's often the hardest part. We'll get into that. Then the financial stuff. The ACH payment form, so they know where to send the money. Or, if the money is going to the attorney's account first, you need the client authorization form.
And the legal paperwork.
Right. Exhibit C, which is the attorney retainer form, has to be on file. And for deceased claims, the list is even longer. You need Appendix A to the claim form, the death certificate, and the legal proof that the personal representative has authority.
Usually letters of administration from surrogate's court.
Typically, yes.
And we really have to stress what happens if you miss one of these items, because it leads to these two different statuses that people always confuse: inactive versus denied.
A very important distinction. Inactive status is what happens if you file the claim before your client has their WTC HP certification. The VCF just puts it on a shelf to wait. No harm, no foul, just a delay.
But denied is much more serious.
Much more serious. Denied is the administrative stop sign. It means you're missing one of those required forms we just listed. A missing signature, not enough proof of presence, no letters of administration. The claim is formally rejected, and the processing clock stops entirely until you fix it and get it reactivated.
So a complete package from the get-go is the best thing you can do for your client's timeline.
It's the greatest procedural gift you can give them.
All right, so let's say you've submitted a perfect package. The VCF says the claim is in good order. It goes into the queue. What kind of timeline are we looking at then?
It's placed in the queue for that substantive review on a first-in, first-out basis, FIFO.
And what's the standard time we should be telling clients? What's the VCF's goal?
Their stated target goal is to issue a determination on the claim or on any amendment within 1 year of submission.
1 year.
1 year, assuming it's in good order. That's the benchmark for let's say, a general non-complex claim.
And what about the complex ones? What's a realistic deviation from that?
Well, complex claims, especially deceased claims, they just take longer. There's no way around it.
Why is that?
For a deceased claim, the VCF has to spend a lot of time vetting the legal authority of the personal representative, validating those court documents, and then doing the incredibly complicated economic award calculation.
Right.
They have to gather old tax records, wage data.
So that internal validation just adds months to the timeline.
Easily. It can stretch well beyond that 1 year target.
Okay, let's talk about the exception. The critical lever for attorneys in serious cases: expedited processing.
Right. This is where strategic documentation makes all the difference. But there are only 2 reasons they'll expedite a claim:
And they are.
documented terminal illness or documented significant financial hardship.
And significant has a very specific meaning here. You can't just say your client is having money trouble.
Not at all. It has to be imminent. We're talking a pending foreclosure notice, an actual eviction proceeding, or a utility shutoff warning from the power company. You need the paper.
And for a terminal illness, you need recent medical records confirming the diagnosis and prognosis.
Exactly. The procedure is you contact the VCF helpline, and then you upload that specific dated documentation. The VCF usually reviews the request to expedite within 48 hours.
And if they approve it, the timeline just collapses.
It's the fast track. If the request is approved and the claim is in good order, the VCFs can process it, issue the award, and get the payment out in as little as 3 to 4 weeks.
That's incredibly fast.
It is. And it's vital for end-of-life planning or keeping someone in their home. And importantly, they issue the payment immediately, but the client still keeps their 30-day right to appeal the amount.
So for everyone else, once that award letter finally arrives, what's the payment timeline?
Okay, so once the award letter is dated, payment processing officially starts the next business day. The special master's authorization takes up to about 20 days.
And then it leaves the VCF.
Right. It goes to the Department of Justice and then the Treasury for the actual payment processing, which can take up to another 3 weeks.
So a good general estimate is?
Payment should be issued within about 2 months from the date on the award letter.
And a key point for clients: the VCF pays the calculated loss in full. It's not in installments.
Correct. One lump sum payment.
All right, let's tackle the evidence challenge. This is where so many claims get bogged down, isn't it? Especially trying to prove where someone was 2 decades ago.
It is. We're dealing with old memories and very often thin or non-existent paper trails. It's a huge challenge.
The VCF has that interactive presence guide on their website, which lists all sorts of documents they'll accept. But the strategic challenge is how you submit them.
This is a critical distinction. It's about certified versus verified documents.
Okay, explain the difference.
So certain documents like union records, school transcripts, company payroll records, the VCF wants them authenticated. They don't just want a photocopy you made at home.
So what makes a document certified?
A document is certified when it comes with a signed letter from the original custodian of that record, the union official, the school registrar.
Yes.
And that person attests that the copies are true and unaltered. This is what you need if the records were sent to the claimant or to you from the claimant.
And then there's attorney verification, which sounds like it carries a pretty heavy professional burden.
It does. Verification is when the records are sent directly from the source, the school, the company, to the law firm.
Okay.
The attorney then has to personally sign a letter attesting that the documents they're submitting are accurate, unaltered copies that they received directly from the source. Can't be a paralegal. It has to be the attorney.
And this speeds things up.
It does, because the VCF trusts the attorney's professional representation, but you can be sure they will ask to see the original envelopes or the email chain if they have any doubts at all.
So what if, after all that, you have nothing? No documents, no witnesses who can sign an affidavit? What's the path of last resort?
The eligibility hearing.
And the way to get one is a little counterintuitive, right?
It is. Your claim actually has to be denied first for insufficient proof of presence.
So you ask them to deny you.
You do. The attorney submits a detailed letter explaining all the exhaustive failed attempts to find proof. And you specifically have to request that the VCF deny the claim for the purpose of holding a hearing.
And at that hearing, the client testifies under oath.
Exactly. They testify about their presence and activities in the zone before a delegate for the special master. It basically comes down to a credibility determination.
But we have to warn attorneys listening about the impact on the timeline.
Oh, absolutely. The VCF is very clear. The hearing process adds a huge administrative burden and will significantly delay the final decision. It's not a shortcut. It is a last-ditch effort.
Okay, let's shift to the medical evidence. We've established the WTC HP certification is the proof of the condition itself, and the VCF doesn't need the whole medical file.
That's right. The health program only sends over the condition name, the category like cancer, and the diagnosis code. That's it.
So when do you need to submit medical records, if the baseline awards don't require them?
You submit them to argue for a higher award based on severity. The VCF has a list of conditions they consider presumptively severe and debilitating.
Like emphysema or interstitial lung disease.
Right. For those, you'll likely get the max non-cancer award of $90,000 without any extra records.
So you're only submitting medical evidence to push for a higher award when the condition is not on that list, but it's still having a huge impact on your client's life.
Exactly. You're providing proof of severity that the simple certification doesn't capture. For things like asthma, GERD, chronic sinusitis, conditions they view as presumptively less severe, you need objective evidence to justify moving above the baseline award.
And that evidence needs to be recent and targeted. Hospitalizations, surgeries, specialist letters.
All of that. And this brings us to a critical administrative rule that can get you into a lot of trouble. The 25-page limit.
Yes. If you ignore this, you're guaranteeing a delay.
Or a denial of the increased award. The VCF says flat out they will not review large volumes of medical records, more than 25 pages, unless you either highlight the relevant parts or provide a written guide, like a doctor's summary letter, telling them exactly which pages to look at.
So sending a box of records is the worst thing you can do.
It's a malpractice risk. The claim will just stall. It forces the attorney to be strategic.
So is it often better to just get one really good, comprehensive letter from the client's oncologist summarizing the impact, rather than sending 200 pages of charts?
Oh, absolutely. A strong physician summary letter focusing on functional limitations and prognosis is far more persuasive. And, more importantly, it's compliant with their rules. They want proof of severity, not proof of volume.
Let's quickly touch on a couple of other administrative roadblocks. Name changes and what happens when a claimant dies.
Sure, these come up all the time.
So if a client's name on her old high school transcript is different from her current legal name because she got married, what do you need to do?
You have to upload a letter explaining the discrepancy, and you have to provide the supporting legal documents. The marriage certificate, a court order, a divorce decree, something that legally connects the name on the old document to the current claimant.
And what about when a client files a personal injury claim and then, sadly, passes away while it's being processed?
Everything stops. All processing, any potential payment, it all halts. The VCF will not proceed until a personal representative is formally appointed by a court and those documents are validated.
Even if the award was about to be issued?
Even then, it's a hard stop. The claim has to be formally converted from a personal injury claim to a deceased claim.
Okay, one last thing on evidence. Let's go back to the private physician process, the PPP. Besides for deceased claimants, when else can an attorney use this?
It's a very limited exception.
Yeah.
It really applies to two other groups: foreign residents who live outside the continental U.S. and can't get to a WTC HP clinic, and people who face a significant documented hardship in getting certified.
Yeah.
Maybe it's extensive travel, or there just are no appropriate specialists in their area.
And there's a key technical requirement for the doctor doing the verification, isn't there?
Yes, and this is crucial. The private physician can't just write a note saying, "I think this is from 9/11. They have to verify the condition using the exact diagnostic essentials and criteria that the WTC Health Program itself has published for that specific condition.
So the VCF is basically making sure the private doctor is following the health program's own rulebook.
Precisely. The attorney has to make sure the doctor is aware of and uses those published criteria.
All right, we've done eligibility, procedure, and evidence. Now we get to the core financial question, compensation. How is it actually calculated?
This is what it all boils down to for the client, and it's really three parts: non-economic loss, economic loss, and then the mandatory offsets.
Let's start with non-economic loss, pain and suffering.
The core principle here, and we have to keep emphasizing this, is that the award is based on the severity and the impact of the condition on daily life. It is not based on how many certified conditions your client has.
One severe condition is worth more than 5 minor ones.
Infinitely more in the VCF size.
So let's run through the statutory caps that govern all of this.
Okay. For non-cancer conditions, the award can range from $10,000 up to a maximum of $90,000.
And for cancer?
Cancer conditions can go up to $250,000. And in the most extreme cases, say someone with multiple separate primary cancers or a cancer with several other severe debilitating non-cancer conditions, the VCF can award up to $340,000.
And we mentioned before, some conditions like sarcoidosis or emphysema are considered presumptively severe and will hit that $90,000 non-cancer cap.
Correct. But for the much more common ones, asthma, GERD, sinusitis, the baseline award is much lower. To get those claims into the mid-range or up to the cap, you absolutely have to submit that targeted medical evidence of severity we talked about.
Let's use a specific cancer example, prostate cancer. There's some very specific rules to get the maximum award there.
Yes, this is a great example of the nuance. So the baseline award for prostate cancer is already high. It's $200,000.
And the cap for a single cancer is $250,000. So how do you get that extra $50,000?
You have to submit medical records proving the severity is greater than the baseline. That means showing things like recurrence of the cancer, metastasis to the other parts of the body, or permanent long-term complications from the treatment.
And the VCF has a very specific definition of long-term complications here, right?
They do. To get the extra compensation, you have to show that effects like incontinence or erectile dysfunction have continued for more than 2 years after the last date of treatment.
So temporary side effects during recovery don't count.
Correct. If the issue resolves within that 2-year window, it won't warrant the higher award. That little detail is essential for maximizing the client's recovery.
Okay, now for economic loss. This is reimbursement for actual financial damages, and it can get really complex.
It can. We're talking about lost earnings, the cost of replacement services, and past out-of-pocket medical expenses.
Let's focus on those medical expenses because the procedure there is full of traps.
It really is. First, they're only compensable for expenses that were paid out of pocket before the WTC Health Program certified that condition.
Because once you're certified, the health program should be covering the costs.
Exactly. The VCF won't reimburse you for things the WTC HP should have paid for.
And then there's the big one, the mandatory monetary threshold, the $5,000 hurdle.
This is a point of failure for so many claims. The total amount of expenses you're claiming has to be more than $5,000. But here's the trap.
Go on.
The VCF has to be able to verify at least $5,000 worth based on your documents. So if you submit, say, $6,000 in receipts, but they can only verify $4,500 because of bad documentation,
They deny the whole thing.
the entire medical expense claim is denied. They did not pay it partially. It's all or nothing.
Which means the documentation has to be meticulous. And for personal injury claims, there's a specific filing procedure, isn't there? You can't just add it to the initial claim.
That's right. And this is to help the client. To avoid delaying the main award for pain and suffering and lost wages, the claim for medical expenses must be submitted as a compensation amendment after the initial award has been determined.
So you get the big chunk of money first, then you go back for the medical expenses.
Exactly. It prevents the tedious verification of every little receipt from holding up the critical initial payment.
And technically, what does that submission require?
The VCF is incredibly strict here. You must use their official medical expense worksheet, and it has to be uploaded in the Excel format.
Not a PDF.
Not a PDF, not a printout. They reserve the right to reject the whole thing if it's not in Excel. And that gets paired with a documentation packet that has itemized bills and proof of payment, like canceled checks or credit card statements.
And briefly on lost wages and replacement services.
Lost wages are a very complex calculation the VCF does, based on past tax returns and W-2s, to project a lifetime of lost earnings. The attorney's job is really to make sure all that historical data is complete.
And replacement services.
That covers the cost of hiring someone to do things the victim can no longer do: housekeeping, childcare, lawn maintenance. You need receipts from a company or detailed, notarized statements from family members who are providing that care.
All right, the final piece of the calculation, and this is often a real shock to clients, collateral offsets.
Yes. The VCF is required by law to subtract any money the claimant received from other sources for the same 9/11-related disability.
What are the most common offsets an attorney is going to see?
Disability payments are the big one. Benefits from Veterans Affairs and YSERS state workers' comp, if those payments are for the same certified condition, they get deducted.
Okay.
Also, any money from a JASTA lawsuit, that's the Justice Against Sponsors of Terrorism Act, or payments from the U.S. Victims of State-Sponsored Terrorism Fund, those are mandatory offsets.
And this isn't a one-time thing at the time of the award. It's an ongoing duty.
It's an ongoing duty until 2090. Claimants are legally required to keep the VCF updated about any new collateral source payments they get, even years after their award was paid.
That has some serious strategic implications, doesn't it? Especially for filing an amendment later on.
This is a critical calculation for the attorney. Let's say your client got a big award, but it was entirely wiped out by a $400,000 JASTA settlement. The net payment was zero.
Okay.
Then, a year later, they get a new minor condition certified. It might only be worth an extra $50,000 in non-economic loss. Filing an amendment is pointless.
Because the existing offset will just eat up the new award.
Exactly. The $400,000 offset just consumes the new $50,000 loss. The net payment is still zero, and you've just wasted a year of everyone's time. You have to do the math before you file.
So we've covered the complexity of eligibility, evidence, and compensation. Which brings us to our final question. Why, if the VCF says an attorney isn't required, is legal counsel so strongly recommended?
Right. And the VCF is very clear. They say no priority is given to attorney-filed claims. Their helpline is there to help. But the value of an attorney has nothing to do with getting priority. The value is in navigating the procedural and legal minefield we've just spent this entire deep dive detailing.
First, let's talk about the fees. There's a legal cap, right?
Yes. The Zadroga Act limits the maximum attorney fee to 10% of the total VCF award amount. It's a hard cap.
Okay, so beyond just filling out the forms, where does the attorney add that indispensable value?
Well, first, managing the documentation. Performing that attorney verification on proof of presence documents. For one, that speeds things up a lot. Second, handling the huge complexity of deceased claims, getting the letters of administration, which can delay a claim for months if it's gone wrong.
And in the really high-stakes cases, managing those expedited requests.
Absolutely. Putting together the perfect package to document a terminal illness or financial hardship to get that 3 or 4 week turnaround, that can be life-changing. And finally, just managing the payment itself, making sure the client gets their funds within 30 days of the firm receiving it.
Now, for what might be the most crucial piece of legal advice in this whole process, the litigation waiver.
This is it. The VCF is a litigation alternative.
Yeah.
That's its purpose. When you file a claim, your client must waive their right to file certain other civil lawsuits.
What kinds of lawsuits?
It's very specific. It's about lawsuits claiming that a defendant caused, contributed to, or made the 9/11 condition worse. The statute is really aimed at product liability claims against a manufacturer or medical malpractice claims against a doctor related to the 9/11 illness.
So it's a trade-off. You take the VCF money or you sue the doctor. You can't do both.
That's the choice. Now, the waiver does not apply to lawsuits against the terrorists themselves, like a JASTA claim,
Yeah.
or against the city of New York for the cleanup response. It's very targeted.
And the consequence for getting this wrong is absolute, isn't it?
It's absolute ineligibility. If a client settles one of these prohibited lawsuits, like a medical malpractice case, after the deadline, they're permanently barred from the VCF. The attorney has to do extensive due diligence on every piece of past or pending litigation the client has.
Okay, finally, let's clearly distinguish between an appeal and an amendment. Using the wrong tool here can waive rights or cause huge delays.
A critical distinction. An appeal is what you use when you are challenging the VCF's decision. You think they got the facts wrong or applied the policy incorrectly in your case.
And there's a very tight window for that.
A very strict 30-day window from when you get the award letter. And filing an appeal stops everything. The whole compensation review for that decision halts until the appeal is resolved.
And it's a long, long wait.
Extremely long. The VCF is currently issuing decisions on appeals that were heard well over a year ago. It's a massive backlog.
Okay, so in sharp contrast, an amendment is for when you have new information.
Exactly. New information. A brand new certified condition from the WTC Health Program. A new type of loss you want to claim, like those out-of-pocket medical expenses. Or new records showing an existing condition has gotten much worse.
And filing an amendment doesn't stop payment on the original award.
Correct. The original award gets paid out. But here's the trap. You cannot file an appeal just to try and speed up an unrelated amendment. If you do, the VCF will invalidate the appeal and you waive your right to appeal that original decision forever.
So the bottom line is, if you're arguing about existing facts, you appeal. If you're introducing new facts, you amend.
That's it, perfectly put. And knowing which tool to use is a final key strategic role for the attorney.
We have covered a huge amount of ground here, a real deep dive into the VCF's framework.
And it really demands that long-term view. Just to summarize for the attorneys listening, register everyone immediately, get that WTC HP certification before you file, master that $5,000 medical expense hurdle, and always focus on documenting severity, not just the number of conditions.
And remember that the duty to report those collateral source payments lasts until 2090. This is a decades-long relationship with the fund.
Which leaves us with the final thought for you, the practitioner. The VCF is a litigation alternative. Your client is waiving specific, valuable legal rights. So the question isn't whether an attorney is needed to upload a PDF, it's whether one is required to navigate the strategic landmines of offsets, waivers, and procedural rules that are going to determine the maximum award and protect that client from making a catastrophic legal error.
That nuanced counsel, managing all that complexity while avoiding those errors, that's the real service here. Thank you for sharing your sources for this deep dive.